May it please, your Lordship.
Yes,
Item number 33, Lordship, I would like to withdraw, Lordship. My grievances have been met and the petitioner has in the meantime retired from service, Lordship. Item 33.
Mr. Your good name, please.
M. Bhagavati.
Mr. M. Bhagavati, learned counsel for the petitioner submits that he has the instruction to withdraw this petition. And as per granting him withdraw the same, there is allowed. This WPC number so stands a disposal upon withdrawal.
Madam.
May it please, your Lordship. Lordships, item number 5 for today's list, my lord. As mentioned for other side also. Can we take an on 8th, my lord? Today some difficult.
When?
8th of May, my lord.
8.
My lord is Thursday, my lord. Sometimes required for hearing, my lord. Already service is completed. All affidavit file and reply also file, my lord.
Mr. N. Bora, learned counsel for the petitioner, press for listening the matter on 8 of, with concern from the other side, press for listening the matter on 8 of May. Yes,
May I please, your Lordship, with the consent of the petitioner, Lordship, I beg to mention item number 24 of today's list. Lordship, in this case, we have to file our affidavit and we need 4 weeks time, Lordship. And for UGC, Lordship.
Miss, your good name, please.
K. Borpuzari on behalf of HOB.
K. Borpuzar,
Borpuzari on
learned
behalf of
counsel.
HOB.
A date may be fixed, your
For
Lordship.
UGC with consent from the other side, press for listening the matter
A date
When?
may be fixed.
Lordship, after 4 weeks.
after 4 weeks. After 4 weeks, parallel.
May
Any
I-
objection?
No, a date may be fixed, your Lordship, if possible.
On 2nd June, after 4 weeks, 2nd June.
May I please, your Lordship, I beg to mention item number 40.
40.
40. With the consent of others.
Yes.
Oh,
When?
on 14th
14th of May.
May, yeah.
Mr. Your good name?
JP Borua,
Mr.
On
J.P.
behalf of-
Borua, learned counsel for
be processed for petitioner.
the petitioner with consent from the other side, press for listening the matter on
14th.
Actually, on 16th, 14 we have cases, on 16th.
Deeply obliged.
May I please, your Lordship? Lordship, with the consent of the other side, I beg to mention item number 16 and 17 of today's list, Lordship. In this matter, Senior Advocate S. Sharma is appearing for the petitioner side. Today he is not well. So,
16 and 17.
yes, Lordship. So the matter may be adjourned for the day, Lordship.
Who will appear?
S. Sharma, Satin Sharma, Senior Advocate.
Okay. Mr. Your good name, please.
S.K. Dekar.
S.K. Decker, learned counsel for the petitioner with consent from the other side, press for listening the matter. When?
Adjourned for the day, Lordship.
Press for adjourning the matter for the day. Parallel.
Deeply obliged.
Yes.
Lordship, I may be allowed to petition for the listing of admission column. The petition is about non-release of the salary during leave period.
You go to court number 2. That is senior court today.
Lordship.
May it please the Lordship. Lordship, with regard to item number 34, Lordship, that connected matter is listed before court number 2 today, Lordship. It being WPC 7477 of 2020,
Item number 34.
Lordship.
Okay.
The connected case is WPC 7477, Lordship of 2022. This matter is listed
74
77,
77 24
22,
22.
22, Lordship. That matter is listed before court number 2 today, Your Lordship.
Hmm.
So may I pray that both these matters may come up together after 3 weeks, Your Lordship.
No, I don't know what order will be passed there.
Lordship. List this matter along with Lordship 7470.
Okay, Mr.
N bottom, Lordship.
Learned counsel for the petitioner, press for listing this matter along with WPC number 7477 2022 after
3 weeks, Your Lordship.
3 weeks.
Lordship.
Parallel.
Lordship.
May I please, Lordship? I beg to mention item number 42 for adjournment today.
42. Miss, your good name, please.
P. Bora
P. Bora, you are
on
appearing.
behalf of U. Sharma.
Mr. P. Bora, learned counsel appearing on behalf of Mr. U. Sharma, learned counsel for the petitioner, press for listing the matter after
After 1 week.
1 week. But what is your instruction? You have not received any instruction.
Any date
Okay.
maybe.
After 2 weeks, after 2 weeks. Yes,
Lordship, I beg to mention item number 12 and 13, Lordship. I have taken already consent of the petitioner side, Lordship. This matter,
you are for respondent,
I'm for respondent, Lordship.
respondent number,
That's not in item 12, Lordship, that's number 3 to 6.
yes,
And item 13, Lordship, 3 to 5.
8 to 5. Okay, Mr. Sutradhar.
Yes, Lordship.
Lordship,
Sutradhar, learned counsel for the respondent number 3 to
Lordship, I am
6
for the
in
petitioner.
item number 12. And 3, and in the other item, other matter,
3 to 5, Lordship.
3 to 5. With consent from the other side, first for listing the matter
After 2 weeks, Lordship.
after 2 weeks.
Lordship, Lordship, there is interim order, it may continue.
Okay, interim order passed earlier, shall continue.
My lord, I beg to mention for item number 14, my lord. In this case, my lord, I am appearing on behalf of Mr. Zaid Hussain, my lord.
Mr.
Zaid Hussain, my lord.
Zaid Hussain.
Yes, my lord. This matter may be adjourned for, my lord, 2 weeks, my lord.
2 weeks.
Yes.
Mr. Your good name?
A Hussain.
A. Hussain.
Yes, my lord.
Learned counsel appearing on behalf of Mr. Zaid Hussain. Learned conducting counsel for the petitioner, press for listing the matter
2 weeks, my lord.
after 2 weeks. Fair law.
Obviously.
Yes, madam.
Your Lordship, my lord, item number 29. Kindly be closed the contempt petition,
29.
29.
Okay, it has been complied with.
Not complied, actually against that order. They have filed review, then again case is pending. So contempt does not, they want to pursue, madam.
Okay. Ms. K. Devin, learned counsel for the petitioner, submits that she has the instruction to withdraw this petition.
Yes, madam.
Withdraw this petition. Mr. SM still learned counsel for the convener present. Ms. David submits that petitioner is not willing to pursue the matter. And as such, she pays for allowing her to withdraw the same PR is accordingly allowed. Conduct each number so starts dispose of or withdrawal.
My lord, further item number 31, kindly be passed over for the date. After adjourn for a week, my lord, I would like to file impleading petition.
Okay, Ms.
31.
David, learned counsel for the petitioner. Pays for listening the matter after a week so that she may file additional affidavit.
May it please your lordship, with regard to item number 47 of the supplementary list, my lord. My lord, I'll be required to file an additional affidavit, my lord. So the
47.
item number 47, bail, my lord.
Mr.
VK Borua, my lord.
VK Borua, learned counsel for the accused, submits that he may be granted some time to file additional affidavit.
Lordship.
Here alone.
Next week, my lord. Highly obliged, my lord.
Date, Lordship. On 9th, on 9th, May,
Highly obliged.
Okay, 9,
before. On 7th,
7.
Highly obliged.
May I please, lordship? But I beg to mention item number 18, lordship. In the item, lordship, I have already filed an IA, that is also allowed. But due to oversight, I could have filed the amended cost title, lordship. So within a week, lordship, I will file the amended cost title. Matter will be taken after a week, lordship. Item number 18.
You are for the petitioner.
I am for the petitioner, lordship.
18.
18.
Okay. Mr. A. Decker, learned counsel for the petitioner, submits that he
So
may be
there is
granted
one more, I
week
think,
time to file
Item number 19 also.
19 or
The connected matter, lordship.
18 and 19.
Yes. But counsel is different. I am representing item number 18.
But who is for 19?
19.
Yeah, we will grant the adjournment.
Lord,
We'll call the matter.
lordship. Obliged.
item 1. Order for implement of party.
May I please, my lord, this, my lord, IA has been filed for impleading the party respondent, my lord. Now, my lord, we have described the, my lord, page 6, my lord, lordship will find Page 6, my lord, prior portion, my lord. The respondent number 8A, 8B, and 8C in connection with the contempt petition number so and so as contender number 9, 10, and 11. Because the earlier my lord, contender is not holding the post. My lord. New government has come.
Yes, Mr. Bora,
I am requiring for respondent number 6, my lord.
respondent number 6, any objection?
No, my lord.
Heard Mr. M.A. Mondal, learned counsel for the applicant, and Mr. S. Bora, learned standing counsel for the respondent number.
I am not as this is contempt, my lord. I am requiring for respondent number 6. This is a contempt.
Respondent number 6.
6.
Respondent number 2, Mr. SMCC for respondent number 2. And for 1, people are like that. Huh? This interlocutory application is prepared by the applicants for implement of Narayan Kaur and Srimati Suranjana Senapati and Sri Akashdeep as contender number 9, 10, and 11. In the contempt petition number 410 of 2021. Mr. Mondal, learned counsel for the applicant commits that the earlier contemners in place of the earlier contemners, new incumbents join, and they are required to be implemented as contender number 8, 9, and 10. Mr. Bora, learned counsel for the respondent number 6 in contempt petition number so and so, and Mr. Sansi for contempt number 2. Submits that they have no objection in the event of allowing this application. Here, taking note of the facts and circumstances of the record and also the submission of learned counsel for both the parties, this interlocutory application stands allowed. Sri Narayan Kaur, Secretary to the Government of Assam School Education Department, and Srimati Suranjana Senapati, Director Elementary Education Assam, and Sri Akashdeep, Principal Secretary BTC, Kukrajar, shall be implemented as respondent contender number 8, 9, and 10.
9, 10, and 11. My lord. It should be 9, 10, and 11. Because earlier 8 is there, my lord.
Okay, 9, 10, and 11. The other petition is also same.
Same, identical.
We are requiring for respondent number 6 and 5 and 6.
5 and 6. Bora for 5 and 6 in item number 2. 60 for 1. Okay.
Oblige.
And as for admission, 2 and 3. Sorry, 2 and 4, 3 and 4.
In item number 2, I am making for respondent number 4.
You are okay.
Respondent number 4 in contempt petition. In item number.
Who is contender number 4? Who is contender number 4?
4.
Who?
Deputy Commissioner.
Deputy Commissioner. Okay. Your good name, please. Is it?
May 3 and 4.
3 and 4, my lord. My lord, I'm just, my lord, refreshing the, my lord, mind of this court, my lord. There are 2 civil division, my lord. The first civil division, my lord, is against the impugned order dated 34, 2024. And so far the first one is concerned, my lord, we made an application, my lord, being the legal heirs of the, my lord, defendant number 1, who expired. that we are not necessary party, therefore we are sought to be impeded. Therefore, we may not be impeded. That was rejected by the court on the plea that, my lord, at this stage, it is not possible, it would prejudice the interest of the plaintiff. Therefore, my lord, to challenge that order and in support of my contention, if I can establish, my lord, that the relief sought for by the plaintiff, my lord, is not against the defendant number 1 or defendant number 2. Because the relief of the plaintiff, my lord, only in respect of portion of the land, which is measuring about 10 into 65 feet. And this particular, my lord, piece of land, which he is considering to be a public path, claiming advantage right over that portion of the land, is a part of plot number 4. And plot number 4 is, my lord, plot number 4 belongs to defendant number 3. And my lord, from the lord, at page 94, I have referred to already, my lord. Page 94, Lord, may kindly have a look, my lord.
So where is the impugn order?
Impugn order is, my lord, at page, at last page, my lord. At district 153. 153.
No, there is no page number 153 in CRP number 40820.
My lord, kindly take up the matter of 40 I am, my lord, 222, 2024. This is the first revision petition.
Page number
53. Have a lordship got, my lord?
153 is
Item number क्या मानेगा? Item to कौन? Item तो खुदा ना. Revision, civil revision number 222. Item number 4. Item number 4.
yes. Page number
153. 153.
153.
153. Order dated 34/2024.
Okay.
Yes. No, it will. May I read, my lord?
Yes.
The instant J case number, J case has been out of a petition number so and so filed by the defendant, cited under Order 1 Rule 10(2) CPC for striking out the names of the defendant number so and so and the defendant number 2 on being joined my lord, improperly. The learned counsel on behalf of the petitioner orally submitted that the claims of the petitioner opposite has stated in the plaint is for elementary is for elementary right over the plot number 4 and the defendant number 1, 1A, 1B, 1C, and 1D, and the defendant number 2 are the owners of plot number 3. There is the wrong projection method. We are not the owner of plot number 3. Owner of the plot number 3. We are the owner of plot number 3. All right. Which is no way connected with the relief claimed by the plaintiff opposite. Hence, the instant petition. On the other hand, the learned counsel for the OP side filed their written objection. The learned counsel on behalf of OP side orally submitted that the defendant number 1, so and defendant number 2 executed document number 3 and 4, which is cell deed and power of attorney. And being so, they are necessary parties to this suit. Peruse this here and have considered the submission of both sides. Upon perusal, I'm of the opinion, it cannot be decided or ascertained at this stage whether the defendant number one is so and so, and defendant number two are necessary party or proper parties. Having said that, any order for striking out the names of the defendant number so and so at this stage prejudice the plaintiff or opposite party. Therefore, the basic reason given by the court in rejecting the petition is that at this stage it is not possible to determine. And secondly, if their name is struck off, then it would cause prejudice to the plaintiff. Now, my lordship will appreciate the section itself, particular provision itself shows if they are necessary party. There are two basic aspects of the matter. One is whether plaintiff is going to be prejudiced or defendant is going to be affected if any decree is passed. And if I say, then I'm not going to be affected by the decree if any passed. Matter ends. And that's why we didn't appear. Secondly, if I can show on record that plaintiff did not seek any relief so far as defendant number 1 and 2 are concerned, because his relief is limited only to plot number 4, because the suit path is a part of plot number 4, and it runs from west to east, taking it on to south and north, and we are residing in south. It does not touch the land of the defendant. Therefore, if any relief is granted to the plaintiff, declaring easement right over that particular piece of land, schedule number 2, schedule B, we are not going to be affected. So on that consideration, my lord, how one can say we are necessary party? And if any decree is passed,
Mr. Professor,
my lord,
whether any relief is being sought for against you by the plaintiff?
no, nothing.
No. Nothing.
No relief is sought for, because relief is sought for only in respect of schedule B, and schedule B is a part of plot number 4. Plot number 4 belongs to defendant number 3, and we are the owner of plot number 3, and relief is sought for in respect of plot number 4, portion of plot number 4, measuring about 10 into 65 feet. Therefore, if you don't seek any relief against me, how can you say I am the necessary party? That aspect was not taken into consideration. And my lord, there is one decision on this point, my lord. Of course, my lord, I am not going to trouble your lordship. My lord, court may show moto or upon an application by the party may consider whether a particular party is necessary or not. Therefore, my lord lordship, if your lordship kindly look at, my lord, page 94, it's a part of record.
Yes, this is a
Black portion, my lord, black portion. It will not a plot 4. And suit path is, my lord, situated on plot 4. It is a part of plot 4. And we are the, my lord, owner of plot 3, which is far away from, my lord, plot 3. We are not even the boundary man of plot number 4. Plot number 20, different number 3 is the boundary man of, my lord, plaintiff.
no, in page number 94, there is no indication about plot number 4.
But I am saying, my lord, black portion is plot number 4.
Which portion?
Pardon, my lord?
Black portion.
Black portion.
Okay.
And what is that?
Five.
And plot number 5 is the land of the plaintiff. Yes. And our plot is plot number 3. Extreme south, my lord. And it took a turn from west to east towards, my lord, north. Eight is to us, record. It is to us. And lordship kindly. Page number 94. Page number 94, my lord, I have given, my lord, black portion and extreme, my lord, bottom. There is a suit path. Schedule B. And different number, my lord, 4 is the adjacent to shoot path. And plot number 2 is adjacent to shoot path. Plot number 3 is not adjacent to shoot path. And my lord, should kindly see the, my lord, prayer made in the plane. Page 35. Huh? 34. Page 33. Defendant number 1, my lord. Defendant's a declaration that the suit path is a private path of the plaintiff and pro forma defendants and the plaintiff has got the easement right about the suit path by the prescription. Therefore, my lord, apparently it appears from, my lord, prayer number 1. The defendant does not have any, my lord, right of, my lord, easement. Defendant, plaintiff and the pro forma defendants, they are having some easement right about that plot of land. Therefore, we are nowhere connected. We don't have any, my lord, claim about this particular piece of land. Therefore, if we say that we have no claim, and if any relief is granted to the plaintiff, we have no objection. So how can you be, my lord, be necessary party in the suit? And if decreased part in course of time will be precluded from, my lord, raising any question. And on the other hand, that whole stand is that we approach the defendant number 4, who is the builder, my lord, authorizing him to take all sort of steps for development and construction of the building. So those documents is a document, my lord, executed jointly by all the person, all the defendants. Now they are relying on that. My lord, whether by virtue of this document, one can say the status or the right of the defendants is a joint status or joint state, whether the property is a joint property or joint state. We purchase the land by separate sale deed, my lord. Therefore, we have our individual and independent right title interest. And whatever, my lord, property is involved, that property doesn't belong to us. Therefore, on that point of view, my lord, the order passed by the court is not justified. Secondly, my lord, they substituted. A composite petition was filed. So by this time, my lord, other division petitions concerned, related. Then court Somoto, without hearing us, court Somoto, my lord, substituted the legal heirs, saying that, my lord, there is no objection raised, and earlier order was, my lord, passed, rejecting the claim of the prayer of the, my lord, defendants, not to substitute them as party in the suit. Since that order was passed against the defendants, therefore they have no right. But the order doesn't reflect whether delay was condoned or not, because there are huge delay. They didn't even give any explanation. So unless and until delay is condoned, how can court pass this order? Of course, it is, my lord, it is for the court to examine whether court can Somoto condone the delay or not. Even if the court has got the power to condone the delay Somoto, there must have some reflection. There is a delay is condoned, court is satisfied, and now court is going to substitute the legal heirs of the defendant number 1. That was not done. Therefore, on that point of view, my lord, subsequent order is not justified. Apart from on merit point of view, since we are not the necessary party, we are not seeking any claim about the suit property, nor plaintiff sought for any relief against us. Therefore, we cannot be constituted to be necessary party. On other days, my lord, I have already submitted, and this is the only question court is to examine whether any relief is sought for against the, my lord, defendant number 1 and 2, and in that eventuality, whether the legal heirs of defendant number 1 can be said to be necessary party, can they be implemented as necessary party? And what would be the consequence? The moment I will say that I am not necessary party, I don't want to, my lord, contest this suit, then I will be precluded subsequently. If the decree is granted in favor of the person who, my lord, made a prayer for withdrawal, for deletion of his name or striking out of his name, subsequently he will be precluded. He will be prevented from raising any sort of question. This is my submission. And if they may not make any submission, I will reply.
Lordship, the suit was filed in the year 2019 under section 25 of limitation. Act.
One by one, you first come to this CRP number 22224.
222.
Yes.
Triple two, that is, it has become infructuous. He did not challenge the order, final order. So second, 2 to 4, 408 becomes, now let us come to the 408 only. Because to triple two, the final order which was passed in our favor, that was not challenged by the petitioners.
This is the only order.
Now, the suit was filed in the year 2019 under Section 25 of Limitation Act, limitation by prescriptions. 19, thereafter COVID started, plaintiff died, substituted, mother died, then present plaintiff was substituted. It took a lot of time. During that period, they started constructions. And written statement was filed by defendant number 4. He is also no more now. He also died. Defendant number 4 is the attorney of all defendants, including the present petitioners. The present petitioner who happen to be legal heirs of defendant number 1, never filed his written statement separately, relied on the statements of defendant number 4.
No. Dependent for
You submitted, I did not object it. Now let me.
No, you don't make a wrong statement.
Now, at this stage, maintainability of that petition, when they are supposed to raise at the very earliest, they did not come at that time because they allowed the construction to be carried out. When it is almost completed now, it is ready for sale. At that time, because they have faced the difficulty of Form 50, because of pendency of cases, they cannot sell those properties. Therefore, they have come before this honorable court for citing out the name of this. Now, under order 1 rule, under order 1 of CPC, order 1 of CPC, who may be joined as the defendants? All persons may be joined in one suit as defendants who have the right to relief in respects of arising out of the same act or transaction or series of acts or transaction is alleged to have exist in such person, whether jointly or severally or alternative. Here is the case. There is a common power of attorney. Building permission is common. Construction, all the documents are common. True to sell this are there. Now it is a project is also one project. Now at this stage, suppose I would not have implemented him as a defendant number 1, predecessor of the present defendant, the question of non-gender of necessary property would have arisen. Now at this stage, whether there is any evidence to show that photograph which they have shown, sketch map, they have alleged their own writing. It is not given by issued by any authority. They have drawn the photographs. At this stage, without evidence, without documents, all those things, whether this court will, as a revision petition, will be able to assess that one, whether they are necessary party or unnecessary party. Now at this stage, because of pendency, now they have raised, now the composite petition, what they talked about, where the defendant number 1 died, we got the information. We asked the advocates of the conducting advocates for their advocates to inform the courts on which state he died. He did not inform to the court as he is bound under order 22 rule 10A. He is supposed to inform to the court that his duty ends. He did not inform. And the same person in the same suit, he conducted, Mr. Borua has conducted before the trial court. Now he has come on behalf of defendant number, predecessor of the legal heirs of defendant number 1 again. He had the knowledge that defendant number 1 died. Then for want of specific date, we filed a composite petition. Under that composite petition, we prayed for substitution, setting aside abatement and limitations. In that petition, they did not object it. They did not remain present before the learned trial court at the time of hearing. Now they have come in the revision petition that they were not heard. They are unnecessary.
Where is that composite petition?
All right, Lordship. That composite petition.
There's a CRP number 408.
Oh, 408.
Page number?
They themselves, they have also given. In the main petition itself, it is there. Westmere plain that this was written statement order passed in music case number of the department in order passed in the petitions. Then subsequently they have filed. Petition number a composite petition from Robert.
কোনটো পঢ়ি আছে আপুনি? 22,
Anyway,
triple two পঢ়ি আছে।
triple two, my 408, triple two, it also gets.
Triple two আমিতো এতিয়াতো আপুনি triple two আৰম্ভ কৰি আছে।
All right. Triple two, it is in triple two. It is at page 134, 147, annexure 11.
কিবা কাটা কাটি পানি।
134, an application under section, under order 1, rule 10(2) of CPC for, it is their petition for striking their name. That was rejected.
ভালে।
বহুত ডকুমেন্ট হৈ গৈছে।
আপোনালোকৰ prediction sir। আপোনালোকৰ prediction sir হয় না? Everything opposition। At page 164।
164,
Opposition sir।
164.
You will find at page 164 of their affidavit opposition.
Page
164
164.
of their affidavit opposition in connection with triple.
60. 160. Oh, that is there.
Hundred and four in which matter?
164.
Triple two.
Triple two, 164. There is an application under,
164 is an affidavit.
no,
Yeah,
Lordship.
yes, that
Yeah,
affidavit.
triple two, in triple two at 164,
164.
164.
164 is a affidavit.
In that case, madam, they have an X. That affidavit operation, they have an X.
No, in our affidavit in opposition. Affidavit in opposition, in triple two. An application under order 22 rule 4.
Yes.
So now, okay, we did not inform.
This is the composite petition filed by plaintiff. An application under order 22 rule 4. Then again in the same application under order 22 rule 9 for setting aside abatement. An application under section 5 of the Limitation Act. Because for want of definite date given by their advocate before the learned trial court, we were forced to file this application. We did not know when he died. Therefore, at utmost caution, we filed composite petitions. There is no harm. Because he is the duty bound to inform the court, that trial court, so and so that he died. He died. He did not give us. We only knew the length of the legal years. As such, we were forced to file. We even today also we do not know when he died. Neither they have informed this honorable court that on so and so that he died. Therefore, there is nothing wrong in this petition. And this petition was duly allowed by the learned trial court, and they did not object it at that time. Whether they can raise objection before this honorable court at revision petition, by way of revision petition. My submission at this stage, the case has been, it is by the time and every construction has been completed, they have nothing to do with anything. They have encroached the part of the suit path and they have made construction over the country by way of country level. We are not able to go. There is no vehicle cannot pass. That they allowed the things to proceed without hindrance from because of the fact that the learned trial court did not give us injunction at the time. Thereafter, we file appeal. The appeal is also pending for want of this revision petition. Now, at this stage, we are helpless now. We are not able to get the road. And we have a definite right over under Section 25 of Limitation Act. Therefore, my humble submission before this honorable court, the learned trial court has not committed any error by substituting names of defendant number 1. If defendant number 1 does not have any of these things, that will be decided in the trial, not by way of revision. Therefore, for want of this thing, this revision, both the revision petition liable to be rejected. Let them better proceed so that at least if we are not entitled to relief, all right, we'll see that if we are not able to prove our case will go. Now, why they have so much hurry now? Question of maintainability has to be raised at the very first instances. They slept over 2019, 2020, 25, 24, till that they kept on sleeping.
Mr. Bhagwati, please tell me whether you have claimed any relief against them?
Because Lordship, the problem is that now the relief cannot be separated at this stage because documents are common. All the 4 documents are common. Construction permission is common, power of attorney is common, MOU is common. And one more, what is that called? And subsequent construction permit, NOC also has been obtained. Common, by way of common. WSS is common. Now at this stage, whether they can be, and this point, whether it is not maintainable against him, he should have been raised by him. The person, defendant number 1. Defendant number 1, at that time, he kept quiet. Now, legal heirs of defendant number 1 has come before this honorable court, and this has been conducted by the same advocate. He conducted the case on behalf of power of attorney holder, builders, and he conducted the case on behalf of the defendant number 1 also. He never said that I did not stood. And power of attorney clearly says that defendant number 1 will, defendant number 4, attorney holder will conduct the case on behalf of all the persons. Therefore, the written evidence on the written statement filed by the defendant number 4 is stood common for all the defendants. Therefore, at this stage, whether by of revision petition, whether he can be separated or not. That needs evidence whether that particular the photos which they have shown it sketch map. It is sketch map is drawn by them.
No.
Even we do not know. Tomorrow, when we lead the petition, when we lead the evidence, we may not. Yes, that may not be required. But whether they can claim all those relief right now at this stage or not, after operation of 7-8 years. That maintainability question has to be raised always at the earliest. So therefore, right?
You tell me now in this 408.
408.
408. Where is the impugned order?
In the 408, they have impugned order. Impugned order, it is 27/6/2024. Annexure.
At page 91.
91.
19. Start from 19. Start from
91.
91. Lordship, the plaintiff and defendant A, B, C, D are represented by them. Plaintiff, defendant number 1, 2.
It starts from 90.
Allah.
Not now, 90.
It is same. Actually, they both the copies common copy. Double file double. Plaintiff and defendant number 1, A, B, C, D are represented. That means on that day, all the defendants were present. The present petitioner were present before the London trial court. Perusal of the CR reveals that petition number 2156 filed by the plaintiff side for substituting the names of legal heirs of deceased defendant number 1. The names of legal dependents are Sri Jayanto Daka, Sri Rumi Daka, Srimati Papuri Daka, and Srimati Minakshi Daka. Perusal of the case record reveals that although the petition was pending for disposal, the defendant side filed a petition on 2299 praying for striking out the names of defendant number 1A to 1D, and defendant number 2 being the defendant number 2 being improperly joined. The said petition striking the names of defendant number 1A, B, C, D are and defendant number 2 are disposed with a observation that the court that at any order for striking out the names at this stage might prejudice the plaintiff opposite party, and according the said petition was rejected. Perusal of the case CR reveals that neither side pointed out the court that the petition 2156 was pending for disposal. Further, perusal of the CR reveals that defendant side has not filed objection in respect of petition number 2156. They did not file any objections. Having said, it is presumed that the names of Jayanto Daka, Srimati Papori Daka, and Srimati Rumi Daka, Papori Daka, Srimati Minakshi Daka are legal heirs of these defendant number and hence their name are to be entered in the cost title of the plain. According to petition number 2156 stands allowed with read with the order dated 30/34/2020 passed in mistake case number 188/2024. Also, petition number so and so filed by the petition side seeking the names of amendment of the petitions. Hence allowed. Here is the case, the earlier deputy. This order is a conjoint order. On the order dated 30/2024 and order dated 27/6/2024, it is considered a conjoint order. Why? Because this petition was pending, and this petition was a composite petition filed by us, on which the court passed the order, and they did not file their objections. They were at least they should have already objected before the learned trial court that this petition is not maintainable. That they did not do it. Now they have come in a revision. They cannot come because they are. Why? Because when they did not object before the learned trial court, either they should have supported the petition or they should have objected it. Even they failed to perform their duties that so and so died on so and so day. They did not inform the court on that after the death of the defendant number 1. Now they have come in a revision challenging the order without any objection, without hearing. Therefore, at this stage, in a revision petition, I myself being the advocate for the plaintiff may not be able to say that this plot will not come, that plot will not come, because it is construction is going on full swimming. Now they have first difficulties because they are not able to sell their plot of both builders as well as owners here. They are unable to sell because of the pendency of the civil suit. That is why they have come. They have filed Form 50 petitions before the courts, and courts have given their pendency of the suits. Therefore, they have come. It is not a bona fide one. It is a mala-fide one. Therefore, at this stage, and for delay is a fatal. 8 years passed. Almost 7 years passed now. At this stage, whether they can do it or not.
In reply to that, my lord,
Mr. Bhagat, the composite petition is at page number
page number 164.
164. In my
in
earlier
triple two. 164. Okay.
My lord, may I just, my lord, make one statement, one submission, my lord. My lord, I have pointed out that lordship will also examine. They did not give any reply. Whether any relief was sought for against the defendant number 1 and 2. That question they altogether may they ignore. They did not even make any submission. Let them, my lord, make it clear that whether any relief is sought for against us. If no relief is sought for against us, then how can you be necessary party? Number 1. Number 2, my lord, he is saying construction is going on. He is sought for injunction that was rejected on merit. And till date matter is pending, there is no stay order. My lord, he didn't proceed, he didn't pursue the matter. Therefore, that submission doesn't have any meaning, it is redundant. Thirdly, my lord, lordship will appreciate that, my lord, prayer doesn't say that construction is under challenge. His challenge is only in respect of footpath, portion of plot number 4. Only portion of plot number 4. Now, how can he, my lord, say now at this stage the construction is also under challenge? Construction is not under challenge. His challenge is in respect of footpath. Therefore, whether footpath, my lord, affects our right or not. This is the only question lordship will examine. If he is sought for any relief against us, then we are necessary party. If no relief is sought for, we cannot be said to be a necessary party. There is the basic, my lord, scheme of order 1 rule 10. Therefore, my lord, case was not projected properly. Other days, my lord, we submitted our hajira. And we are, my lord, till, my lord, since the defendant number 1 and 2 did not, my lord, contest this.
Mr. Professor, what prevents you? in presenting your case properly before the trial court.
It will be unnecessary, my lord. We have been dragged unnecessarily.
Unnecessary.
Otherwise, no, we are not in a
Mr.
position to
Bhagwati,
enjoy our
the
plot.
test is whether any relief is being claimed against the petitioner or not. That is the case.
This is the
For
question.
want of evidence, for want of
Yes,
this
no,
thing, cross-examination. Even trial court, if you ask the trial court, I myself being the advocate, I may not be able, because construction is such now that we are not able to enter even. That now their construction is going on even over the suit part.
No. Don't say in that
Suit
way.
part, we
No,
paid
no.
for, we paid for 10 feet. Now it has come down to 5 feet. Because
Don't
of
say in that way.
cantilever, because of cantilever.
Did you make any statement in your objection position that construction is going on footpath?
Because our plane says so. We have amended the plane.
Base
All this-
87 is the clear, my lord, order of this.
Order of the-
I don't know how does he conduct the case here.
Now
When he was representing the defendant number 4 before the trial court, defendant number 1 before that trial court. Same person has come before this
No,
court again.
I
For the
want
this
to
defendant
clear-
number 1. He is barred. He cannot raise all those questions because he was supposed to inform people, learn the trial court, the death of the defendant number 1. That he
Okay.
fails to do.
My lord, one thing,
I can read.
my lord, with liberty,
He
I want
has,
to
he
clear.
has,
One
he
thing-
has,
Yes.
he
my
has
lord,
problem.
My lord, what happened, my lord? 1 to 4, 1 to 3 is the landowner, 4 is the, my lord, builder. Only builder appeared. 1 and 2, 3 never appeared last 7 years. And that is why should be expertise against it, but that was not done. Then when the problem arises, first time they appear, they say that why should we make party, my lord?
Okay, we will pass the order.
Lordship, I will, two rulings will give.
And my lord, Lordship, kindly Lordship have a look, my lord, order 1, rule 10.
No, no, Mr. Progress, all right.
Madam.
Okay.
Now, Lordship has actually pointed out whether relief is sought for.
Your part is open.
My
Yes, sir. Bhagwati, you can. Board pass.
Order is reserved, my lord, I think.
We'll pass the order, not, we will not reserve it.
My lord.
Item number 6. Item number 6.
Your Lordship, kindly pass over the matter for the day, your Lordship.
Why?
My senior is out of station, your Lordship.
Who is your senior?
B. Bhuya. She's out of station, your Lordship.
Who?
B. Bhuya,
Bhuya.
your Lordship.
Your name?
S. Hazarika.
S.
Hazarika.
Ms. S. Hazarika, Learned Counsel, appearing on behalf of Ms. B. Bhuya. Learned Conducting Counsel for the petitioner with consent from the other side, press for listing the matter. Press for stand over the matter for the day. They are allowed. The matter stands over for the day.
Item 7.
May I please, your lordship, items 7 to 11 arising out of same, my lord, issue, that is provincialization of a school. My lord, in office note, my lord, it is, earlier it was in a, my lord, series of case. Since it is a type 1 case, it was segregated and again remanded back to the single bench. Office note, your lordship, kindly see that at 2/4/25.
No affidavit has been filed.
No affidavit has been heard. In the meantime, one development is there, my lord. On the same issue, my lord, one writ petition is dismissed and appeal is pending and it is in a hearing stage. That writ appeal number is 447 of 2023. Can it, this matter may be adjourned subject to the result of that writ appeal? 447 of 2023. There is also series 447, 443, 2023. Two writ.
447 of 2024.
23.
23.
So this item, my lord, item 7 to 11 is subject to the result
7
of
to 11.
7 to 11.
Okay.
Same issue.
So will I check it?
My 447. 2000
Will I check it whether this matter is pending or not?
pending. My lord, last my lord, 10 days ago it was my lord, listed, but after 1 month it has been
1 month.
447. It can be checked.
Okay, heard Mr. N. Hawk, Learned Counsel for the petitioner, and who is for respondent authorities?
No, sir, I'm for secondary education, D. Musa.
Mr. Musare for respondents in secondary education department. Mr. Hawk submits that in connection with the same subject matter, one writ appeal being Read appeal number 447 of 2023 is pending before the division minutes. And till disposal of the said read appeal, this item number 7 to 11 may be adjourned. Fair allowed. This is the matter immediately after disposal of the read appeal number 447 of 2023.
Item 15. Item 15. Item 15.
None appears for the petitioner on call. Madam, you are for?
For secondary education.
And Ms. Musare for
Mr.
respondents
Mohanto was here, Your
in
Lordship.
Education Department present. Mr. Mohanto was here.
He was here, Your Lordship.
Okay, then after some time. Covid, Mohanto is there.
Item 18 and 19.
Yes,
Your Lordship,
they will inform the other side. In item number 19.
he is 19. He's
Acha.
different item number.
Any objection in adjournment?
No.
No. Mr. Decker, learned counsel for the
In
petition.
other words, Lordship, item number 19, Lordship, SSA is supposed to file affidavit. Here also, I have filed IA for implementation of SSA that has been allowed, but because of oversight, Lordship, I could not file the amended petition. That is in respect of 18. But
Okay.
both the matter, subject matter is same for provincialization.
Okay.
And so for the item number 19, the SSA is supposed to file affidavit.
And in item number 19, I have already filed the corrected cost
Lordship,
settlement.
Lordship may pass separate order in item number 18, I may be allowed to file the amended petition.
Okay.
That I get for item number 18.
Item number 18, you take down. Heard Mr. A. Decker, learned counsel for the petitioner, and Mr. P. N. Sharma for respondent number, respondents in elementary.
Elementary department. 1 to 5.
Mr. Decker submits that he may be granted some time to file amended cost title.
Yes,
of the late petition. There is accordingly allowed. Rest is lays the matter after 1 week. And in item number 19, you have filed amended.
Yes, already.
Mr. Your good name, please.
M. Shalim.
M. Salim,
Salim.
learned counsel for the petitioner, and Mr. P. N. Sharma, learned standing counsel for the
Elementary
respondents in elementary education department. Have you filed your affidavit?
Our affidavit is not necessary. SSA is supposed to file affidavit.
Okay.
In last order, yes.
The last order,
reflected.
Your Lordship was directed the SSA to file affidavit.
In item number 19.
Who is for SSI?
Mr. B. Chaudhary.
Bora was there.
He was there.
Which matter? Okay. But no affidavit has been filed by them.
Not filed, madam.
Mark my pay and I'll inform them and grant us some time to file the affidavit.
Okay. Mr.
Please, Your Lordship.
No, no, no.
B. Chaudhary was there.
B. Chaudhary.
Yes.
B. Chaudhary. Oh, B. Chaudhary for SS. It appears that the respondent SSA has not filed Its affidavit in opposition despite direction of this court dated 18/12/2020. Accordingly, last opportunity is afforded to the SSA to file its affidavit in opposition. List the matter along with item number 18. After 2 weeks.
After two. If it is not inconvenient, it may be fixed after 2 weeks. But yes, deep level.
Item 20.
May it please the lordship. The department has not filed any affidavit, my lord. And the earlier occasion, my lord, I have submitted amended cost item, my lord, for completing the respondent number 7, my lord. But in the cause list, my lord, their name has not been shown, my lord.
Oh,
AZ, my lord.
AZ.
AZ, my lord.
AZ will file.
In the earlier occasion, my lord, Mr. SK Mehdi, my lord, appeared on behalf of SK Mehdi, my lord. Appeared on behalf of respondent number 7, my lord.
Mehdi
Mehdi, my lord, SK Mehdi.
is present in the court today.
Earlier, my lord. Earlier, my lord, present, my lord. But not shown in the cause list, my lord.
Okay, okay. Heard Mr. Patwari, learned counsel for the Patiri for the learned counsel for the petitioner.
Lordship, I'm on behalf of SK Media, sir. Lordship, he is out of station.
Out of session. And Miss, your good name, please.
RR Saikia.
Learned counsel for Mr. Medhi, learned standing counsel for the respondent number
7.
Respondent number 7. So you are supposed to file affidavit in
My lord.
opposition.
Other respondent also, my lord, supposed to file, my lord.
It appears that the respondent authorities have not filed their affidavit in opposition. Accordingly, last opportunity is afforded to all the respondents to file their affidavit in opposition. List the matter after 2 weeks.
That may be fixed, my lord. Pension matter, my lord.
Okay.
21st May.
Oblige.
Item 21.
Yeah, please, your lordship, Mr. Ditul Das, sir, is on legs. Kindly the matter be kept for timing, lordship.
For
Time being, lordship. He's on
Timing.
legs, yes, lordship.
time being.
Oblige, lordship.
22. Item 22.
Yes. None appears for the petitioner on call. However, Mr. Ian Sharma, learned standing counsel for the respondents in department present.
I am
Then
for the secondary
Mr.
education department, you Sharma.
Mr. Soliha for finance department. And Ms. So for respondent number 4. List the matter after 2 weeks. In the event of subsequent non-appearance of non-representation of the petitioner, appropriate order shall follow.
23.
None appears for the petitioner on call. However, Mr. Ian Sharma, learned standing counsel for the respondent in elementary education department, and Mr. Soliha for finance department present. List the matter after 2 weeks. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
25.
Please, your lordship. In this case, my lord, the petitioner's son died on my lord 6/6/2017. Accordingly, she is entitled to my lord the compassionate family pension. Now, my lord, without informing her, my lord, there's a requirement, my lord, page 36, that they have to inform my lord that whether she wants to, my lord, go for the new pension scheme or my lord, the compassionate family pension scheme, my lord. Page 36, my lord. This is circular of the government, my lord. Page 36, paragraph 4, my lord. The appointing authority and receipt of information from the Directorate of and Treasuries shall
Lordship, here instruction is awaited, Lordship. I pray for 2 weeks time, Lordship. Already been communicated, Lordship. 2025 matter, Lordship. Lordship may grant 2 weeks time.
Only twice, I think time has been taken, twice or thrice time has been taken, my lord. So
They have
let them
also-
experience this, ultimately it's a pension matter, my lord.
In turn, the director has also communicated to the DEO Lordship asking for all the details Lordship. So Lordship may fix after 2 weeks Lordship. In the meantime, perhaps some instruction will come.
My lord, in this case, my lord, the respondent number 5 is a very important, has a very important role to play, my lord, because respondent number 5 will be, my lord, basically, my lord. It's under them, my lord, the director of accounts and treasuries, my lord. They have to, my lord,
Who will represent this respondent number 5?
Accountant,
Soliha?
is Mr. S.K. Medhi.
No, Director of Accounts and Treasury.
Accounts.
accounts and treasury, my lord, plus government, my lord. I think the government.
Almost Treasury is a department. Finance department. Accounts and treasury. Director of accounts.
You are. So you were supposed to file affidavit.
Lordship, sometime maybe granted, Lordship will file affidavit. One.
Heard Mr. M. Dotto, learned counsel for the petitioner, Mr. P. N. Sharma, learned standing counsel for respondent number 1, 4, 6, and 7. And Mr. Soliha for respondent number 3 and 5.
Yes, Lordship. Respondent number 3 and 5.
3 and 5.
2 and 5, Lord, huh?
2 and 5.
2 and 5.
2 and 5.
And 6, 8 also, I think. 8 treasury officer.
Yes, Lordship.
2, 5 and
5 and
8.
8.
2, 5 and 8. Mr. Sharma and Mr. Soliha praise for granting 2 weeks time to file their affidavit in opposition. They are allowed to rest unless the matter after 2 weeks.
Lordship, I am for 1, 4, 6, and 7. 1, 4, 6, and 7.
1, 4, 6, and 7.
And
Mr. Soliha
3
for
is my learned friend.
Mr. Pegu, Z Pegu for respondent number 3. 3 and 5. So, Mr. Pegu, you are interested to file affidavit? Not required.
No, Lordship, here, अपनी compassionate family pension. Accumulated wealth to.
Low is there because that was without informing me, I had taken the money.
Yes,
I was given the money.
Lordship, here the case. Lordship, if I may, Lordship will file an affidavit, but what has happened is there's an OM that has been published by the AR PPT
Page 36.
page 36,
35,
Lordship.
36. There's a duty to inform.
Yes, Lordship. Here, Lordship, we have stopped the compassion family on the basis of this OM where if the accumulated wealth has been withdrawn by the petitioner, then this OM is governing, and because of which we have stopped the and this is not only in the petitioner's case, there are other people also, Lordship, who have actually withdrawn the accumulated wealth. They are not entitled for compassionate family pension. Lordship will bring it on record, but we are being governed by this. That is why we have. Yes, Lordship. And this is existing, and my learned friend has challenged this OM, Lordship.
In our case is, my lord, that without informing us, there's a duty to inform which option I want to, my lord, put. Whether I want to go for a compassionate family pension or the accumulated fund. Without giving that option, since she's a widow, whatever was paid to her, she received the money. Now I'm willing to return it back. Now the second case is item number 26, I returned the money. They've accepted the money. And I was being paid provisional pension also. Now it has been stopped. Saying that you received this amount, you refund it back, I refunded back the amount.
Then where is
Lordship,
the
that might be the officers might not be aware. When it came to their notice and when this notice came into the knowledge, Lordship, they have stopped it, Lordship. And we are governed by this notification. That is the entire case, Lordship. Now whether, and in that, in this notice, we have specifically mentioned that once that amount is withdrawn, they will not be allowed to repay it back. We will not accept it, and they won't be entitled for compassionate family pension. And now my learned friend is making the submission that they were not aware, Lordship. That is their case. Otherwise, we are governed by it. We know about its existence. And if some officer has as my learned friend has stated, if they have taken the money back, Lordship, they have to come up with an explanation why they have accepted the money, because
At this moment.
That is the next case, this is the
Yes.
next case, not in this case, next case.
The
25, 26, I think 26.
Here,
It happened-
file your affidavit
Yes.
after 2 weeks.
Ultimately, it's a beneficial legislation, my lord. So item number 26, my lord, this is where my lord, I returned the money before this OM came, my lord. Now, the compensation, the pension which I was receiving has been stopped.
Yeah.
Here, my lord, I returned the money much before, my lord, the OM came, my lord. Page 40.
After returning of the money,
My lord.
the OM come into existence.
OM has been issued here.
Okay.
Now, this is, I returned the money, my lord, by challans, my lord. That is at page
So does it
46.
pay the compassionate family pension then?
No, Lordship.
No, here, my lord, regular family, family pension.
Regular family.
Not
not
compensation,
compassionate. Okay. Okay.
Now, Lordship, here, we are aware, Lordship, that is why we have stopped it, Lordship. Now, if some other authority has accepted that explanation has to come by the authority, why they have accepted it despite. And here is not a case of compassionate family pension, Lordship. It's a regular family.
Regular pension,
So
as per
that
the
is-
scheme, as per
That
the
is,
scheme.
that is different. For that, the administrative department will come up with an explanation, Lordship. For the education.
Education also has to come. You also have to explain because since the money was accepted before the OM came, so whether
Yes.
this.
Were accepted
how
by
you
who?
treat
It's
this?
found to give the family pension, regular family pension. then.
Accepted by who? That is.
It's a deposited challan because the education department wanted
Yes,
us to refund the
Lordship,
money.
that is why it is the education authorities in the education department that have accepted it. We are governed by that notification and Lordship, we are strictly following it, Lordship. Once it comes to our notice, we have to stop the family pension, the compassionate family pension.
No, before coming into existence of the OM, they have returned the amount. So they will not be governed by the OM.
Exactly.
Here he is asking for regular family pension, Lordship.
Yes.
So that is has to be clarified by the administrative, that education department, Lordship.
Yes, Mr. Sharma, you have any instruction?
Since it's a pension matter, may I pray for a fixed date, my lord, which otherwise not inconvenient to lordships, my lord.
Okay. Heard Mr. Endoso, learned counsel for the petition, and Mr. Solia for the number. Respondent number 2 in.
Same, my lord, respondent will be same, my lord.
Same
number. Same, response are all same, my lord. 26. Response are all same, my lord. Same parties, my lord.
Okay. Mr. Solia and Mr.
26, my learned friend.
That should be 26, my lord, instruction is awaited. I think 26.
Since when it is awaited?
My lord, I've given my lord in the group, my lord.
Mr. Fukan for respondent number,
My lord, elementary education, my lord.
elementary education part.
26.
As per 2 weeks time is granted to Mr. Fukan and Mr. Solia to file their affidavit in opposition.
Item number 26, Lordship, here we have written to the parent department, we are awaiting the status report from the parent department. So at this moment, we are not in a position to file an affidavit. Lordship. Let them clarify, let them forward the status report, we'll file an affidavit pursuant to receiving the report from the Lordship.
File it as soon as possible, because without your affidavit also we cannot,
As soon as we get the status from the administrative.
we are granting you 2 weeks time. In the meantime.
My lord, we'll give 3 weeks, my lord, because then, my lord, I'll be able to, my lord, because again.
No, there's a
25
pension matter, it is why 3 weeks?
25
weeks.
matter, my lord.
The problem is that you are not aware of which of the party you are representing.
Wait a minute.
I'm appearing for 2, 5 and 7.
So how can I expect that you will come with a affidavit or instruction on next day?
No, my lord. I'll come back.
Anyway, after 2 weeks, probably fix everything.
19
Deeply obliged, your lordship, deeply obliged.
Lordship, may I pray, lordship, with regard to item number 23, lordship.
No, not-
Only
we
my
are
name
not-
may be recorded, lordship.
We are not dealing with item number 23 now.
Lordship, only my name may be
sorry.
recorded, lordship. Item
Obliged, your lordship.
46. 46.
Director to file affidavit, my lord, ARTP department.
My lord, there was a direction to file affidavit, my lord, on last occasion, my lord. Due to some difficulty, my lord, we could not file. I pray for 2 weeks time, my lord.
They have taken again and again time.
Because there is a contradiction, my lord. Finance department has already filed affidavit, my lord. So, my lord, we'll have to respond.
And on the other hand, they are paying provisional family pension,
You were getting it.
getting.
Part Mr. T. Boda, Learned Counsel for the petition. Then Mr. G. Pego, Learned Standing Counsel for the respondent number 1, 3, 4, and 5.
2 and 6.
2 and 6. 2 and 6. Then Elementary Education Department, Mr. Sharma. Okay. Mr. Borua for respondent number 7. 7. 7. Mr. Pegu, Learned Counsel for the respondent number 2 and 6 submits that he may be granted some time to file this affidavit within the position. There is allowed, recess the matter on
27.
sorry, 22nd May. 22nd May.
At
It
this
is,
stage,
it is being clarified that no further chance will be given to Mr. Pegu to file his affidavit.
his name should be reflected in the cause list.
Recess shall reflect the name of Mr. Pegu against respondent number 26.
At this stage, may I pray for payment of DCRG, my lord? I am
That cannot be.
acute financial difficulties, my lord. DCRG, they can release.
Very clear, madam, from the own record that the petitioner was never regularized. Pension is granted only to the regular employees, madam, in place itself. That is the rule.
That's all right. Who is responsible for that? For
Well,
non-regularization of service, who is
there is no
responsible?
such-
I am 23 years, 11 months, 7 days in the service, my lord.
There is no such policy, madam. For the school, there's once a person is well engaged on casual basis, he will have to be regularized. There is no such kind of policy.
They have
May
been.
not be,
Him, but he continues.
may not be, but who is responsible for non-regularization of his service?
Well, that now he's
Mr. Gogoi, one respondent cannot argue against the other respondent, against the order passed by the other respondent.
Well,
That is the principle.
No, I understand, ma'am. There is nothing on record to show that, ma'am, he's entitled. That's what I'm saying, ma'am.
They are,
For a particular document by the accountant general doesn't mean that, ma'am, he will be getting the benefit. Now we are, there is only one stand, ma'am. It's not a that. That is a stand.
We'll
That
see.
is it, ma'am.
You file your affidavit.
Well, everything finance is fine.
on the other hand, yeah, we have annexed that document, my lord, till the posts are filled up with regular basis. Continue to serve me in the department. That annex I have.
Let their affidavit come.
My lord. Obliged, ma'am.
For bail hearing 48.
None appears for the applicant on call, is a matter after 1 week.
24, orders 27.
May please, Your Lordship. This contempt application was filed for non-compliance of an order dated 17/6/2016, my lord. Some time has gone past since then, my lord. I also do not have contact with my clients, my lord. I'm not aware whether the order has been complied with or not. So may I pray that, my lord, some time may be granted to me so that I can obtain instructions from my client, my lord. I've tried to contact, but I was not successful, my lord. That will be after 4 weeks, my lord.
Third, Mr. B. Sharma, Learned Counsel.
Be sure. Be sure.
B. Sharma, Learned Counsel for the petitioner. And Mr. Sisley, you were appearing here?
One becomes like we retired long back lawsuits. Others, most of the respondents, they are no longer holding the post. Anyway, let him take instruction.
Okay. Mr. Sharma submits that he may be granted 1 week time to
Well,
obtain.
let's say 4 weeks, my lord. It's
4 weeks
difficult.
time to obtain necessary instruction. From the petitioner, pair is accordingly allowed, exception is the matter of purpose.
Yeah, much obliged.
28.
Lordship, I'm sorry, in this case, Lordship, we have to file a petition, a notice to the government, new incumbents. That could not be done because the client, my lord, I could not inform the client. So 3 weeks time may be kindly granted, my lord.
Mr.
Further 3 weeks
Arthur
time.
Learned Senior Counsel assisted by Miss
Arbor Ali.
Learned Counsel for the petitioner pays for granting him 3 weeks time.
My lord.
They are allowed. Sister, you are? No.
Obliged, my lord. Obliged.
30.
None appears for the petitioner on call. Is the matter after 2 weeks. After 2 weeks.
31, 32,
May I please read it? Here is the last order, Lordship. 23/4/25.
Yes.
Here is the last order, Lordship. 23/4.
Last order as faithful is the matter on 38/4.
We have to take instruction, let it come after 3 weeks, lordships. We have to take instruction, lordships, from the newly income respondent.
Artemis,
J. Akhtar.
the actor, learned counsel for the petitioner and Mr. 64 contempt notes.
Yes.
Mr. 60 submits that he may be granted 2 weeks time.
Yes, yes, yes.
2 weeks time
Yeah.
to obtain necessary inspection.
Yes.
Fair allowed to release the matter after 2 weeks. So 60, this is of 2020.
Yes. I'm for the newly income, newly included, yes.
35,
Please, Your Lordship. Yes, last is listed on 5/12/2022. My learned friends took time for taking instruction.
Pardon?
It was first listed on 5/12/2022.
Yes.
2022, and my learned friend Mr. 60 took time for taking of instruction regarding area salary, release of area salary of the petitioner. But that area salary of the petitioner here. And the area salary for the period of 1/4/2015 to 2022. That suspension period, he was not taking area salary, but subsequently the suspension period regularized, but area salary not paid. He has filed this petition for directing the respondent to release this area salary.
Instruction is within matter 2 weeks time is given.
The 2022 matter.
1 week.
Heard Mr. Islam, learned counsel for the petitioner, and Mr. Q Sharma, learned standing counsel for the respondents in secondary education.
Secondary education department.
Mr. Sharma submits that he may be granted 2 weeks time to obtain necessary instruction. Here allowed, this is a list of matter. After 2 weeks, reflecting the name of Mr. Sharma against respondents in secondary education department, being respondent number 1, 2, and 3.
Can you fix a date? Other difficult to list, Your Lordship. Last years.
36,
God bless.
Yeah, teacher lordship. My lord, as per Lozima report, my lord, service in respect of respondent number 7 has been completed. And all other respondents have made their appearance, my lord.
Completed.
Yes, my lord. As per Lozima report, my lord, 6/12/24.
So all the respondents completed service.
Yes, my lord, completed.
Heard,
That is
heard means your good name, please.
S. Borpatra Muhammad.
S. Borpatra Gohai, learned counsel for the petitioner, and Mr. Upamunya for respondent number.
Ten.
Higher Education Department.
Respondents in higher
Belongs
education
to law for the-
department. The learned counsel for the petitioner submits that service in respect of all the respondents have been completed, then the matter is ready for admission hearing. Accordingly, it is provided that recessal is the matter for admission hearing on COVID fixed at 2022.
29,
Oblas, my lord.
37,
None appears for the petitioner on call. However, Mr. Upamunya, learned standing counsel for the respondents in higher education department. Place the matter after 1 week. The event of subsequent non-representation of the petitioner, appropriate orders will follow.
38.
May I plead your lordship? Lordship, my senior counsel is in another court. Please, pass over the matter for a time being.
Lordship, I'm referring for the petitioner lordship. As per order dated 9/9/2024 lordship, we have taken steps on respondent number 4 by Dusty Service lordship. We have filed the affidavit
Service completed.
completed lordship. Matter may be fixed for admission.
Okay. Heard, Miss?
As thus,
Yes, thus learned counsel for the petitioner and
that will do.
and Madam Mutare for respondent number?
No, sir, for secondary education, your lordship.
Respondents in secondary education department and you for respondent number 6. It is submitted at the bar that service has already been completed and matter may be discussed for admission hearing. Accordingly, it is provided that
Lordship, kindly date may be fixed lordship.
SSL list the matter on
3rd June.
for admission hearing.
Obliged lordship.
39.
May I please, Lord? This is a
Yes.
contempt matter, Lordship. In this matter, what happened, Lordship, they have deferred an appeal after a year, Lordship. Thereafter, that appeal was dismissed. Thereafter, the last occasion, they have took time, Lordship. If a petitioner is a grade 4 employee, he is not getting salary from last 10 years, Lordship, 11 years. Because of the fault in the part of the government, Lordship. Now, till date, more than year, Lordship, it is over, Lordship, it was not complied, Lordship.
I am appealing on behalf of Mr. B. Kosik, Lordship. That appeal has been, state appeal has been dismissed. Now the file has been, government is contemplating, I have been informed that. So B. Kosik is out of, he requested me to take at least a week time, Lordship, to get up to the instruction.
In the last order, kindly see, Lordship, the writ appeal was dismissed, that part is
Yes,
mentioned.
that was admitted fact, Lordship. It was dismissed and department is considering this case, Lordship. Now, I think they are taking the views of the judicial, I think that exact instruction I don't have, Lordship.
So once the appeal is dismissed, you have no other option but to comply with the
Yes,
order.
they'll have to comply. Yes.
So on the other day, you have appeared in this matter.
On the other day, on behalf of both of them, I have appeared today also, Lordship. But as my name is not listed, I couldn't go through it yesterday, Lordship. Now today they have informed that this case is listed. So he is out of station, Lordship. He has some difficulty.
In the first direction, Lordship, 60 days time is given. Thereafter, 1 year, they have not complied. Appeal was FIFA after a year.
Then this
1
Friday,
year.
Lordship, Friday then.
After
today
1
is Wednesday, I think Wednesday. no?
Friday.
Then this Friday.
Okay.
B. Kosik will come tomorrow.
Art Minister,
Khatuniya, AU Ahmed.
AU Ahmed, learned counsel for the petitioner.
Khatuniya,
and associate learned counsel appearing on behalf of Mr. B. Kosik, learned standing counsel for
Main road.
respondent number.
One.
Contempt of
One.
This is 60 price for listing the matter on Friday. Fair allowed, rest will list the matter on Friday. In the meantime, Mr. Sisti shall obtain necessary instruction in this regard.
Yes.
This regard, and rest shall reflect the name of Mr. Sisti against the contempt in the cause list.
Yes.
Oh.
Item 41.
Sometimes, like, the instruction is within, madam, sometimes it's required, madam.
Okay,
I am appearing on behalf of SMT system, madam.
Heard Mr. N. Islam. Learned counsel for the appellant. No, sorry, petitioner and Mr. Sharma for
Yes,
Mr. Masai assistant learned counsel for the contempt, standing counsel for the contempt. Mr. Sisti submits that instructions are being awaited and the high school listing the matter after 1 week.
Yes.
After 1 week. Parallel recess the matter on approval.
Well, let's say date may be fixed. Well, let's see, early.
13th May,
I'm like,
13th.
Mate, please, Lordship. There is a contempt matter, Lordship.
Lordship, I am applying for respondent number 2, Lordship. So I am applying for 3 weeks then for filing affidavit.
Why?
Lordship, these are two compliance of the order, Lordship. He's seeking filing affidavit. Lordship, kindly see the page,
Contempt matter.
page number 16, Lordship, kindly see. Long back, Lordship, order has been passed, Lordship, page number 6. I am
Wait, page number?
16, Lordship, 16 and 17. Paragraph number 16, Lordship.
Paragraph number?
16, Lordship. May I read it?
Yes.
The petitioner in petition number so and so having secured higher marks than the petitioner number so and so and Srimati Korovidas, there is no occasion to apply the procedure clause in the advertisement in terms of the judgment of the Supreme Court quoted above. Consequently, the selection and recommendation of the so and so by the selection committee as assistant professor, Department of Assam is hit by Article 14 of the Constitution of India. The selection and recommendation of Srimati Korovidas as assistant professor Assam is accordingly set aside. It is also seen that in the lead petitioner, that is I am Lordship, has secured the highest marks in the selection process. The selection committee of the state respondent directed to make the selection and recommendation of the successful candidate slowly on the basis of the marks secured by the candidates. In much as there is nothing to show the candidates that they are mentioned in the tabulation sheet, don't have the other eligibility criteria to be appointed to the said post. The said exercise should be concluded within a period of 3 weeks from the date of receipt of the copy of the order. Consequently, the order dated so and so is. Lordship, after this, Lordship, the 3 mark, Lordship has been passed. Lordship, I have submitted the copy, Lordship. This is Annexure 18, Lordship. But now they are seeking, Lordship. 3 exams earlier, Lordship.
Lordship, and Lordship, I am appointed as principal on 31/5/25. Lordship, therefore, I have forwarded a copy to the director seeking instruction to as to what to be done for compliance of the aforesaid order, Lordship. And instruction is yet to be received. So I may be allowed 2 weeks time, Lordship.
I think
Lordship,
selection.
learned counsel for the petitioner and madam, your good name?
P. Soria.
P.
Soria.
Soria, learned counsel for the
Respondent
respondent's
number 2.
contempt now. Ms. Soria submits that she may be granted 2 weeks time to receive the instruction. Here allowed, this is the matter after on, accepted after 2 weeks on
16 May.
16.
Lordship, then contempt petition is against the director also. Director have also received the notice. Lordship may look at it.
You have only one,
For respondent number 2, Lordship.
two.
One has also office note 20 for Lordship. Duly received.
None appears for the respondent number 1, though, as per report, no, though office note 20 dated 25/4/2025 indicates that notice has been served upon respondent number 1 as per report of the process server. But the respondent number 1 remain unrepresented today. Registrar shall put up one up to that office note on next date as to whether any council entered appearance on behalf of respondent number 1. This is the matter of 16.
Item 44.
May it please your Lordship. Lordship, this IA has been filed for modification of the order dated 7th of April 2025, Lordship. Lordship, on 7th of April 2025, Lordship, a submission was made by the advocate of the petitioner that the name of the respondent number 2 may be struck off, Lordship. And Lordship, Lordship, may we please to come to page number 10, Lordship, of the IA, Lordship. Lordship, but it has been reflected that Mr. Chaudhary, learned counsel for the respondent number 1, submits that the name of the respondent number 2 may be struck off from the from the area of this petition. Prayer is allowed at the cost and risk of the petitioner, Lordship. The name of respondent number 2 has been struck off from the area of this petition, Lordship. Lordship, instead of respondent number 1, it is the petitioner who had made the submission, which was accepted by this honorable court, Lordship. Lordship, in second paragraph, instead of Mr. Chaudhary, learned counsel for the respondent number 1, it should be Mr. Iqbal, counsel for the petitioner should be reflected, Lordship.
Now, what correction is to be made?
Lordship, the correction is in paragraph number 2 of the said order, Lordship. Instead of Mr. Chaudhary, learned counsel for the respondent number 1, instead of Mr. Chaudhary, respondent 1, it should be Mr. Iqbal for the advocate appearing for the petitioner, Lordship. It is the petitioner who had made the submission, not the respondent number 1, Lordship.
Yes.
My lord, we have no objections. My lord, it is the petitioner who had made the submission. I may be allowed. However, my lord, the matter has been fixed on 9th in the industrial tribunal.
When?
On 9th, my lord.
May.
Yes, my lord. Hence, my lord, I pray the CRP may be fixed prior to that, my lord.
Why?
On 8th. Because, my lord, there is no stay in this application, my lord. No stay has been granted as of yet. And the matter has not been admitted.
No, on the other day, there was a pair for listing the matter on 19th of May. Therefore, it has been listed on 19th of May.
My lord, actually, we made a prayer for 8th, my lord, due to some clerical error, maybe, my lord.
Hard miss.
Arboro, Lordship.
Learned counsel for the applicant, this interlocutory application is prepared for correction. Now, for correction of typographical error that occurred in the order dated 7/4/2025 in JPIO number 89 of 2025. And also hard miss, sir.
G. Imtiaz, my lord.
G.
Imtiaz.
He is a learned counsel for the opposite party, respondent opposite party. Ms. Borga submits that in the order dated 7/4/2025. While striking out the name of respondent number 2, it has been observed that at the cost and risk of the petitioner, the name of the respondent number 2 is struck off from the area of this petition. But instead of the petitioner, it would to have been respondent number 1.
Yes, Lordship.
Respondent number 1. Mr. Imtiaz, learned counsel for the opposite party, respondent opposite party, submits that he has no objection to the event of this interlocutory application being allowed by this court. Whereas taking note of the submission of learned counsel for both the parties, it is provided that henceforth in the fourth paragraph of the order dated 7/4/2025, at the place of at the cost and risk of the petitioner, it should be read as at the cost and risk of the respondent number 1. For all purposes, in terms of the I since closed. So for listing the matter, you can mention the matter, not the.
Yes. If I may, my lord, I'm appearing for the petitioner opposite party, my lord, not respondent opposite party. For the petitioner in
No,
this
in this petition.
Yes,
in
yes,
this
my lord,
IA,
for this opposite party. Yes. Thank you.
45.
May I please, your lordship?
Yes.
Lordship, on 4/4/25, your lordship had passed an order where my petition has been disposed, directing us, giving us 1 month time to give the payment, release the payment to the respondent, lordship. On 5/4/25, after the passing of the order by your lordship, on 5/4/25, the petitioner number 2 had communicated with the respondent to give the details against the for the financial sanction, but to be deposited to the finance department for releasing of the payment on 5/4/25. Finding no response from the respondent side, again on 23/4/25, petitioner has again issued a letter to the respondent requesting them to give us the details against whom the financial sanction has to be issued from the finance department. Lordship, that letter has also been received by the petitioner and by the respondent on 26/4/25. This is the postal receipt, lordship. And yesterday they had come to the office of the petitioner number 2 and seeking some time to give the details of their against whom the payment has to be released. That's why I'm in this. I am praying for another 2 months time so that we can release the payment. Otherwise, payment is we don't have any issue with the payment, lordship, as per the direction issued by your lordship on 4/4/25 regarding release of payment. We are ready to release the payment, but for financial sanction, that has to be deposited. That has to be deposited to the finance department. The name of the respondent against whom the payment is to be issued. That is the main problem, lordship. So they are seeking time, lordship. I have annexed the letters also, lordship. That is Annexure 2, page 11, and Annexure 3. That is the letter dated. One is the 5/4/25 letter dated. That is Annexure 2, page 11, and 23/4/25 letter dated, page 12, lordship. The reminder letter.
Another 2 months time.
Lordship.
Why?
Because they are seeking time, lordship. The respondents are seeking time to furnish the details. Until and unless we receive the details.
Where is that document?
Lordship, they have come verbally to the office of the petitioner number 2 yesterday evening, lordship. As I have been informed.
This is regarding execution of the decree.
Lordship, that is.
So this way we cannot grant any time to you.
Lordship, I do understand, lordship, but if your lordship goes through my petition and the letters which we have issued and the last that they have received also, the postal consignment, this one, tracking consignment. Till that I have means, in a sense, we can say that till that we have not received response from their end, lordship, because of which we are helpless, lordship, to release the payment. Because earlier the case was filed by, not this one. Earlier the case was filed
Who
by.
appeared for the respondents?
No, lordship.
Decree holders.
Earlier, the case was filed by their father. After the death of their father, that is the main, this one CRPIO 119 of 2025, page 18. Lordship, 1, 2, 3. Respondents have, the name of 3 respondents have came out. Lordship, may kindly peruse this one, lordship. Now the payment has to be released in the name of.
Who appeared before this court on the other day?
No, lordship, no one has appeared. Because on the very first day, your lordship had disposed of the petition, giving us 1 month time. The order passed by your lordship, I have annexed in Annexure 1 and page 8, lordship. Running page 8 in IA. 8 to 10, lordship.
Or is the RM, that's learned counsel for the applicant. This interlocutory application is paper by the applicant for extension of another 2 months time for releasing the payment to the respondent by the petitioner. Mr. Das is referring to a letter dated 23rd to 2025. Submits that after the order being passed by this court in CRPIO number 119 of 2025. The aforementioned letter was addressed to the degree holders for furnishing the death certificate of Fauzi Mohammad Khan, legal heir certificate, drug succession certificate, NOC from other legal representative, and bank documents, PAN card, GST, registration certificate, certified address details. And the said letter was received by the address by the degree holder, namely Mr. Kabir Muhammad Khan. And thereafter, 3 degree holders approached the applicant to grant some time to furnish the details being sought for by letter dated 5/4/2025. Earlier letter dated not 23rd 4, but 5/4/2025. And thereafter a reminder was issued on 23rd 4/2025. And thereafter they approached the applicant seeking some time to furnish the details as sought for by ordered by letter dated 5/4/2025. And the said requirements are yet to be furnished by the degree holders, and as such, Mr. thus contented to grant the applicant to 2 months' time to make the necessary payment as per order of this court dated 4/4/2025. Having heard the submission of Mr. Das Learned Counsel for the applicant, I have carefully gone to the order dated 4/4/2025 passed by this court, and also the letter dated 23rd 4/2025. No, 5/4/2025. And the letter dated and the reminder dated 23rd 4/2025. And also the postal receipt. Taking note of the submission of Mr. Das Learned Counsel for the petitioner, this court is inclined to dispose of this interlocutory application by granting 1 month time to to the applicant to comply with the order of this court dated 4/4/2025. Terms of this is and supposed 1 month time.
Timing item 15.
May it please the lordship. My lord, here in this case, my lord, the petitioner service was not been, my lord, provincialized, and that order I have challenged before this honorable court. And after, my lord, run through the pleadings, my lord, this honorable court asked the respondent authority to education department to give a particular reply on a particular subject, a particular para. That is, your lordship kindly see paragraph 19 of my writ petition. Paragraph 19. Because in Sanskrit, my lord, there is not a single teacher, my lord, provincialized, and criteria as per law is that, my lord, in the last exam, my lord, at least 10 students has to be appear. So, in a particular subject. So in para 19, page 18, your lordship kindly see. 11 page 19, my lord. So that was, my lord, I have given details. 2014, 15, 16, 17, 18, 19, 20. These are how many students appears, my lord. That this honorable court specifically asked them to file a affidavit on this table. That your lordship kindly see order dated, my lord, 29, 2023.
As Neogi Learned Council for the Secondary Education Department, has your lordship got it, order date 29? Government Assam pair for adjourn the matter and verify information contained in para 19 at page 19 with the read petition, which shows there are numbers of students in the subject Sanskrit in Madhuri Panduri High School, Madhya Panduri High School, higher secondary school as shown here therein for the purpose so and so. So that was the order, my lord. But again, on your lordship, kindly see 8/2/2024. 8/2/2024. Same order was passed by my lord on 18th, but they have filed a reply. But avoiding that, my lord, regarding paragraph 19, my lord, not a single line, my lord, they have written. So I filed a reply also against that affidavit. So that is the situation, my lord.
So, madam, you comply with the order.
Lordship.
Dated, 28/9/2023.
Lordship, we had filed our affidavit on 28/2/2024, your lordship. Yeah, in the affidavit, your lordship, though specifically it has not been mentioned about paragraph 19, your lordship. But
Yes.
we have stated that in the year 2016, the enrollment was 6, your lordship. That is what we have stated in paragraph 4, your lordship.
No, regarding this table, as per order of this
Table?
court, dated 28/9/2023.
Lordship.
At that point of time, court wanted to ascertain whether it is a correct or not.
Lordship, for the year 2016, your lordship, the table that is shown is the students that appeared is 6. And we have stated in our affidavit that the student were 6, due to which the petitioner was not, the DLC had not recommended the petitioner's name. Student that appeared, that had enrolled in the subject Sanskrit is 6, your lordship. So it should be 10, your lordship. As
But-
per the rules, as
But they have not answered my lord 17, 18, 19, 20.
because your lordship, as per the act, your lordship, section 3, clause 7, your lordship. For provincialization of service of one teacher or tutor as the case may be,
Page number
page 110, your lordship.
110.
Amendment.
Yes.
7, your lordship. For provincialization of services of one teacher or tutor as the case may be in each subject, including the core subject. In case of Venture High School or Venture High Madrasa or High Secondary School or Venture Senior Secondary School, at least 10 students must have appeared in the last final examination in that particular subject from that institution. Further, for provincialization of services, a maximum limit of 12. So the student, 10 students must have appeared, your lordship, in the last.
10 student in the last
Exam appeared.
Last exam.
So my case was considered in 2021. And that is also not correct. It is, my lord, it is amended in 2018. Same para, my lord, same thing. That means, my lord, even my lord, my learned contention is correct. Then, my lord, it will be on last minute 18. Your lordship kindly see 18, my lord, our student, my lord, 2014. 14 student. So last exam. So my case was considered in 2021. So my last exam is what? 21, my lord. So in 21, my lord, it is last exam is 20, sorry. 22 student, my lord. So that's why this honorable court specifically that asked that the answer on this table. So they are stick on 2016. Yes, 2016, they're not there. But my case was considered in 2021. Your lordship kindly see the impugn order. Impugn order was passed in 2021.
Page number
55, my lord.
No, but 55 is the order passed by this court.
Oh, sorry, my lord, 59. 55 is the past earlier order, my lord. I'll just send back to the government to consider my case. So that order, your lordship kindly see.
Page 59.
59, my lord.
Yes.
Your lordship kindly see the last but 2 para, my lord.
So this speaking order was passed on 25th of April 2022.
Yes. Your lordship, as per the Assam, last but 3 para is, my lord, only that regarding against me, my lord. As per the Assam Education Provincial and Service Teachers Reorganization Educational Institution Act 2017, as amended in 2018, the enrollment should be 10 in the year 2016. That is absolutely wrong, my lord. 2016 as amended in the year in the last exam. So 2016, my lord, they have put for rejecting my pair, my lord, they put 2016. But it should be as per law, it should be in the last exam. But if it is considered in 2022, so last exam will be what, my lord?
21.
21, my lord.
21 is not here.
No, not here, my lord, because at that time, your lordship kindly see, I have given, my lord, 2022, my lord, actually. 2022, my lord. Sorry, 2022. When this, my lord, the exam was not held, probably. That's why, because of the COVID, my lord, that was not given.
21
My
exam
lord.
was not held.
No, whether exam on hold or not, but I have a record up to 2022. 2022. So, but your lordship kindly see, while the process was going on, probably 2021. So the order was passed in 2022. But how they can consider in my 2016, in that way, only that year, my lord, one less student was there. Only that year, my lord. So from the start, my lord, your lordship kindly see, only 2016-17, there are less student, my lord. And other, my lord, all fulfilled, 12, 14, 16, 20, 20. So that order is prima facie wrong, my lord. Even they mention is, yes, last year. Last year means what? But just before consideration. So that's why, my lord,
Yes,
this honorable.
last year, as per this order was passed on 25th of April 2022.
22.
So last exam would have been 21.
21.
21.
That's why, my lord, their reasoning was to, my lord, specifically they were asked to file their certificate. They mentioned only
Year 2021 exam was not held on account of COVID.
Yes, but if your lordship marks me, I'll 21, there are 20 students, 22, 21 students, 23, 32 students. That, my lord,
Then,
later on I received.
Mr. Monto, you do one thing.
My lord.
So if we go by the act.
Yes, my lord. The last
year,
correct.
Then we have to examine.
Yes.
We have to test the legality of this impugned order.
Correct.
On the basis of the enrollment made in the last year, means
My lord.
2021.
My lord.
The said fact shall be brought on record.
My lord.
telling
My
an
lord.
additional-
But fact remain, prima facie that order, impugned order is bad, my lord.
Prima facie, it is
But-
bad.
No. My lord, I'll
But we have to clarify the
My
matter
lord.
that they have to take into account the number of students in the 2021.
my lord, I'll vote in it.
May I make a submission, your lordship? Lordship, here, the last year, that will be counted from when this act had come into effect, your lordship. And the act had come into effect on 5th of May 2017, your lordship. The year that will be counted is from 2016, your lordship. The last year will be 2016.
No. That interpretation
That is amended
cannot
in
be, cannot
It was
be-
amended in 2018, your lordship.
maybe.
Last year will be counted from the year this act had come into force, your lordship.
Is there any indication in the section itself?
No. My lord, always, my lord.
Lordship, this has been clarified by a coordinate bench, your lordship.
Why?
Let me place that on the next date. Let me place the decision, your lordship, because in that case, it has been clarified from when it will be counted, your lordship. In fact, your section 4, your lordship, which in section 4 also, your lordship, section 4, your lordship, 115, your lordship. In case of teachers and or tutors of the schools for special subjects, 115. Section 4,
Yes.
clause 4. In case of teachers and or tutors of the schools for special subject like Sanskrit, Arabic, Hindi, craft teacher, music teacher, and other classical teacher, the number of students appeared in the concerned final examination like HSLC and HS 10+2 conducted by the SEBA or the so-and-so as the case may be shall not be less than 10 students in each year. In each class per year during the last 3 years.
This has to be also seen, your lordship, that there has to be 10 students
If
last
this
3
is the
years.
requirement, then here we have to count it from the year 2018-19 or 19-20-21.
Lordship. Lordship, on the next day, let me clarify, your lordship, since there is also a decision by the coordinate bench, your lordship, clarifying this position, let me place it, your lordship. And
No, last year means can it be interpreted as the year prior to enactment of this act?
lordship,
Yes.
Can it be?
yes, your lord, because
I don't think so. Heard Mr. Monto, learned counsel for the petitioner. Then Ms. Musare for respondent in secondary education
Secondary,
department. After hearing learned advocates of both the parties, it is provided that Mr. Monto shall file an additional affidavit bringing on record the number of enrollment in the concerned school in the subject of Sanskrit in the year 2021.
My lord.
2021. In the meantime, Ms. Musahari, learned counsel for the respondent authorities, may also file additional affidavit pursuant to order of this court dated 20th-9/2023.
Deep jokes.
Listen, we will fix it then.
My lord. My lord, 14 May.
Coming under 21.
In this case, our limited prayer was to release of the area salary of the petitioner also. On the last occasion, learned standing counsel from the secondary department has placed the instruction showing that the petitioner has received the amount. But I sought time from your lordship that in order to make the confirmation from the petitioner lordship. But lordship, I tried my best, but I lost contact with the petitioner. I heard that her son has expired, lordship. That's why he's in bereavement. So I don't have any instruction whether she has received or not, but there is one endorsement I have found, lordship, carrying the signature of the petitioner, lordship, saying that she has received. And
On the last occasion, I had pasted, your lordship, the entire instructions where she had given her undertaking that she had received it, your lordship. There's an acknowledgement, your lordship.
but
I had placed the instructions. The acknowledgement has been given and her signature has been put, your lordship. She has herself acknowledged that she has received the amount.
I lost contact, lordship. Just I have received information through a third party.
Now tell me what to do.
And lordship, the one more confusion I am having, lordship. There's certain deductions, lordship. The petitioner is saying that she has received 2,73,488, but in the deduction table, some 30,000 something is deducted, lordship. But that after deduction, it comes around 2,42,000. But petitioner is saying that she has received entire amount. That is the only contradiction I have found, lordship. So I'm on the part of my taking instruction, also I'm helpless, lordship. That's why I have received information through a.
The DDO says that she has received the amount that has been sanctioned is 2,73,488, your lordship. There is no deduction, your lordship. It must be the TDS. Deduction or anything.
So then what to do? So we close the matter.
Lordship, lordship, let me do one thing, lordship. Let me send a letter to the petitioner. Lordship may fix a date. After 3 weeks, I'll send a letter to her address so that my obligation may not be there, lordship.
Mr. Das, learned counsel for the Mr. Das, learned counsel for the petitioner, and Musari, learned standing counsel for the respondent in secondary education department. So thus submits that though he was granted time to obtain instruction in respect of receiving the amount by the petitioner, yet he could not contact with the petitioner, and he prays for granting him 3 weeks time,
That's it.
so that he may send on letter to the petitioner asking him, asking her to furnish the required instruction. There is accordingly allowed, there is a matter after 2 weeks or 3 weeks. 3 weeks after. On.
26. Item 49.
Item 14, I have instruction that the treasury officer has been able to generate that bill lawsuits. That they have generated the bill, so it will be cancelled, will be paid within a day or two lawsuit. The treasury officer is pursuing lawsuit.
Okay.
Yes, now that problem has been solved, that informed by the DO to me lawsuit.
Okay.
So now treasury officer will be paid lawsuit within a day or two by next day
That
or
is, regarding this,
regarding that area, we have sent a proposal to finance. Now, as soon as the approval
this
given
is
by the
regarding the current salary.
this is regarding current salary.
Current salary.
So,
For
because
earlier
of
salary,
it is in the finance department for
finance
their approval.
department.
And because of that inactive GPF lawsuit current salary was unable to pay, now they have approached the finance, it was activated and the bill has been generated today itself. I have been informed also.
Okay.
Yes.
So, will list the matter in the next week then?
After 2 weeks, that will be better.
Date may be fixed, short date may be given, my lord.
Okay.
My lord, everything is on his favor, short date.
Last, my
whatever
lord,
lordship-
more than 9 years, I have waiting, my lord. Not a penny given, my lord.
That is because he was appointed in a non-existent post. There is some lacunas,
my lord,
lordship, that is there. Anyway, we are not going to that.
Two case, my lord, who referred this judgment, my lord. Already they have, my lord, complained long years ago.
My
they
lord, when the
have
complaint
complained.
has been generated, there is no question of arguing. lordship.
Short date may be given, my lord.
Okay.
Finance will have to sanction this lawsuit for the area. The current he will get it by next week.
Soliha, please expedite the matter.
I will supply him the copy lordships. Yes. And the current by next week he will get the current salary.
Heard Mr. Guhai, learned counsel for the petitioner, and Mr. SMP60 for the learned standing counsel for the respondent, contempt. And also heard Mr. Soliha, learned standing counsel for the finance department, who appeared before the court pursuant to order of this court dated 29/4/2025. Mr. Sisti, learned counsel for the contempt, submits that the arrears on the current salary of the petitioner will be deposited in his account within 1 or 2 days.
Within by next week.
Period of 1 or 2 days, and the matter of releasing of the arrear salary, the matter is pending before the finance department, and accordingly he pressed for listing the matter after
2 weeks
1
loss.
week.
2 weeks. By 1 week, that day may not be able to sanction lawsuit.
May not be.
Yeah.
In the meantime, I
Yes,
will.
yes.
They given the status, my
Current
lord.
salary will be released. Yes.
Yes,
May not
after
be-
1 week. In the meantime, Mr. Sisti shall furnish the required particulars to Mr. Solia, learned standing counsel for the finance department, so that he can expedite the matter of releasing the area salary of the petitioner during the course of the day. Furnish the required document.
Yes, I'll WhatsApp it.
Please the matter on cover 1 week. 9th May.
Yes. Most of DS,